Yes, yes. Is this the one?
This is his.
Huh.
And then
And the
after-
other one is by, I think, uh, the Lexus Nexus one.
That's me.
Oh, sorry.
Okay, perfect. Thank you. Also,
So-
only two of us have slides.
Okay.
Okay.
Hello. Good afternoon to all of you, and welcome to this session, a very interesting session today. This being the last working session of day 1, I'm sure all of you are very tired because of the excellent quality of food that you're having, great speeches, eminent personalities who have come and shared their vast experience with us, and of course the bonhomie that we see in such conferences, meeting friends from different areas, different places, different parts of the world, and it's always great fun to be in such events. The last session is of very, very current interest to all practitioners of law, of course to others also. And for this session, we have the proud privilege to welcome Justice Subramaniam Prasad, Judge of the Delhi High Court. To introduce him to an audience in Delhi is quite unnecessary, but because we have so many people from different parts of the world, it's my duty to say a few words about him. He was an eminent practitioner in Delhi. He worked as an advocate on record in the Supreme Court, and I happened to be his immediate neighbor in Niti Bagh, and that's how our friendship association continued. His father-in-law is a senior advocate, Mr. Balakrishnan. He was my godfather in Delhi, and he comes from a family of very simple folk, as they say, simple living and high thinking. He was a very, very active practitioner. He is designated as senior advocate. He did a lot of, I would put it in inverted commas, high profile cases in the Supreme Court, and appeared for many political personalities, many governments, and earned a great name. He got elevated and went to his native town of Chennai, though he lived most of his life in Delhi, and after a short stint in the Madras High Court, he's come back to adorn the bench in the Delhi High Court, which is a premier high court in this country, which exercises a lot of original jurisdiction in intellectual property and other matters. And he has been rendering a large number of very interesting judgments on the bench. And I was pleasantly surprised when he just whispered to me now that being a judge gives great deal of satisfaction because one works without any outside pressure. The only pressure that you have is your own pressure to keep up your quality of work. And the work is high profile in the sense that very, very busy schedule, and it's very nice to see a person of his caliber coming for this session today. Please heartily welcome him. We have 3 interesting speakers. I remember my visit to Sabah, and from there we have Roger Chin. He's from Sabah, Malaysia. He's a prominent legal practitioner, and he's a member of various international lawyers organizations, including the Commonwealth Lawyers Association. He's been working tirelessly for upholding the rule of law, which is most appropriate for this conference, and very active in the Commonwealth Lawyers Association. He's sought after in many, many capacities in Sabah with government and quasi-judicial departments. His experience in international trade missions with vast legal experience, and it's nice that somebody of his caliber has been able to find the time to be here, and I've had, of course, the pleasure of meeting him in Sabah and Kuala Lumpur, and again here as part of Law Asia. Another lawyer who I had not met is from the lovely city of Paris, as the French call it, and as we call it, Paris. She became a lawyer in the year 2006 with a master's degree from Paris, and she worked as a counsel in law firms for many years, and she is a member of the Paris Bar Council from 2019, and she is very active in many organizations which take up the cause of harassment, discrimination, etc. And she's also been very active in the field of disciplinary actions and in the Bar Association of Paris from 2024-25 onwards. The other person, thank you ma'am for taking the time. Bienvenue et merci beaucoup. We have another eminent personality amongst us, and that is, I can say, our own Gayatri Raman. She's been associated with Law Asia in all our past ventures, and as all of you might know, the Law Asia, we have instituted a Human Rights Award, and LexisNexis, whom she represents in Southeast Asia, as the sponsors of that award for the next 5 years. She's a passionate advocate, doing a lot of work, pro bono and others, in different jurisdictions coming within the purview of Law Asia. She's a member of the Rule of Law Steering Committee, an initiative of the United Nations Global Compact. She worked on creation of a framework for business to support rule of law. She's engaged in many educational activities locally and globally, and prior to coming to head the Southeast Asia business, she trained as a lawyer, and she's been working with LexisNexis from 2001 in various fields. The last gentleman there is someone you've seen on stage, off stage, in the dining room, in the coffee room, everywhere else, as they say, Sarvantaryami, because as the General Secretary of Bar Association of India, I was wondering how his white turban has remained white. It should have been wet by now with sweat. But he is ever smiling Amarjit Singh Bedi, the gold medalist, advocate on record, partner in a law firm, regularly appearing in the Supreme Court and various other high courts, practicing in the field of commercial law, security law, and most of all, he is the backbone of Bar Association of India, an able support for our President Prashant Kumar. Thank you, Amarjit ji, for this contribution you are going to make. After introducing the guests, I'll just focus a minute on what the subject is today. Now, just now I was online. I excused myself from this meeting. I went down and opened my computer, and I was able to log into the Executive Committee meeting of Law Asia, which is taking place right at this moment. And the President and 3 other officers who traveled from here to join the meeting from the office, new office of the Bar Association of India, got caught in traffic. So the meeting was to start at 2:30. At 2:25, the President logged in from the car, And then he said, sorry, we're still on the way, and would you give us 10 minutes time to reach the venue, and then we'll continue. So I was jokingly telling him, you're catching up fast with me, because most of the times, whenever I join Law Asia meetings, I'm in the car traveling from one place to the other. And the day they see that I'm not in the car, they say, oh, Mr. Naganand, you're not in the car. So, I mean, you're sitting somewhere at home. So this is the digital age in which we have come. So how does this digital age work? What exactly does it do for us? And is it good? Is it bad? Is it something which enables you to cross the time zones? Because most of our meetings, there's somebody from America. In fact, we're just joking, our Secretary General is now somewhere in Europe, and he said, it's a good time for me, 11 a.m. in the morning. And another person who was in Sydney says, sadly for me, it's Saturday night, 8 o'clock in the evening, and I'm sitting and doing work. So this is the digital age which has dawned on us, and we're going to have experts speaking about it. And I'm sure Justice Prasad, with his experience at the bar and later on the bench, will have a number of interesting things to say about how things are shaping up in the Delhi High Court, because Delhi High Court has been in the forefront of adopting technology, and I'm sure he will share his experiences. And I thank all of you for joining us, and let's get on with this meeting, and hope that all of you enjoy the session. Thank you. Over to Justice Prasad.
Thank you, Naganand sir, for this, for your kind words about me. Good afternoon to all of you. So as sir said that this is the last session, and we are the night watchmen. And it's not our job just to take the day through, but to score some good runs also. Well, as Naganand sir introduced the topic, we are in a digital age. When we started practice in 1990, and many contemporaries are there, Subhash sir is there, Rachna is there, when we used to get packets from the state, from a local lawyer in any state in the country, and we would draft our special leave petition. So we give a first dictation, we get the first draft, we correct it, the whole thing is typed again with corrections. Then a third draft, the same thing typed all over again. And then when the draft is approved, we used to get stencils cut for it to be cyclo-styled, because you had to file 4 copies in the registry, plus a few copies for us, for the office, some copies for the process, and if there are a number of respondents, then we'll preserve the stencils so that we don't have to cut the stencil again. And that's how the filing took place in the Supreme Court. And the same was there for other places also, where it's get 1+3 or 1+2 typed manually, which was corrected 3 or 4 times. People had to stand in queues to get their petitions filed. After getting a favorable order, we had to again stand in a queue to get our order copies. We got on with it. 8-9 years passed, and suddenly the computers came. The benefit of computers was that we didn't have to retype the whole thing again. We could carry out corrections straight away on the monitor. Things developed further. The registry started getting computerized. We got more confident about the lists being made. Life became much more easier that way. And then we stopped getting the lists, because we used to get a manual list of about 600 pages, about 500 pages. We used to check it manually, see which all cases are there for the particular office. And if we miss it, we miss it. Matter dismissed in default. And then the list started coming in computer, where with a find button, we could find out whether the client's case is there or the advocate and records case name is mentioned in the list. It became easier still. As far as courts were concerned, we had to be in the court. If you are out somewhere, we had to take an adjournment. And then came the problems of adjusting your board, depending on if you have to take an outstation brief. As time has gone, and because of COVID, things took a sudden U-turn. People could access courts even though they were not in the city. A client could log in into the hearing to see whether his points are being canvassed properly or not. A lawyer could join the proceedings from wherever he is. So access to justice became easier and faster. With that, many other things happened. For example, the orders started getting uploaded immediately. You could access to the order, get the access to the a court copy of the order, not the certified copy, immediately. Messages could be sent to the jail so that a person who has got bail is able to be released, because every moment after a bail order is passed in his favor is illegal detention. You can now see your court board and the position of every board sitting at your house. Every high court started getting linked, so you can get an order copy or a copy of any order in any high court, now for that matter, in any court now, at any place, without asking an advocate there to get you the copy. That is the development that has taken place thanks to this digitalization. Now, as far as the governance is concerned, the purpose is to ensure proper services are given to the citizens of the country and use of technology. Start from your income tax returns, all your licenses and permissions, your municipal taxes, your building permissions, submission of plans, ease of business, which has now become the mantra. Use of technology for the development, for the ease of people, for the benefit of the people, is now the present day mantra, as I say. But with that has come challenges also. We've seen cyber frauds, we've seen the entire bank accounts being emptied because of a wrong click. We've seen invasion into privacy. Of course, all of us, we will be discussing Puttaswamy later on. To what effect? And the second problem is that access to this digital transformation is limited only to a few. Its reach has not yet, as far as India is concerned, it's not yet reached various parts of the country where the people are predominantly poor. People, for entering into a contract, we are having problems as to which will be the jurisdiction. For intellectual properties, again the question of jurisdiction becomes of importance because you are clicking on a contract on the computer itself. So these are a few facets for which we need a much more robust cybersecurity system. We need more legislations which will help in developing technology and at the same time not infringe into the privacy and other rights of persons. So with that, I'd request Nagaran sir to start.
I propose that we'll go as per the order. Thank you, Justice Prasad. Roger, a few minutes you can take, and at the end of it, if there is some time, maybe I will pose some questions, Justice Prasad may pose some questions to all of you and see how you react to it, so that it will make it a little more interactive.
Good afternoon, everyone. In Malaysia, we built an app that could tell you if you've been near someone with COVID-19. But what it couldn't do was tell you who owned your data, what law protected it, or how it might be used tomorrow. That's where digital governance meets the rule of law. Digital tools aren't add-ons anymore. They mediate identity, verification, enforcement, licensing, dispute resolution, even surveillance. And here's the problem. When these tools are rolled out before the legal framework is ready, something flips. Instead of the law guiding technology, the technology starts to govern. That's not just a tech issue, it's a constitutional one. Oops, sorry, just trying to get, okay. They can strengthen the rule of law, but only when they stand on solid legal footing. We've seen the benefits. Malaysia's e-Kehakiman system, which is an e-filing system, sped up filings and kept hearings running throughout the pandemic. But in parts of Sabah and Sarawak, weak broadband meant that only online courts could be locked out rural communities out of justice. In 2019, fixed broadband penetration in Sabah was just 2.7%, the lowest in the country. Even today, only about 20.9% of premises are connected. Mobile broadband is better at 78.5%, but that still lags far behind the national average of over 127%. We've also seen how digitization can make things faster, like land office applications in Sabah. But a faster decision made without legal authority is still a bad decision. And yes, digital tools can improve oversight through audit trails in procurement and licensing, but storing data isn't enough. True transparency is about the public's right to see and challenge it. Still, in Malaysia, the same legal problems keep showing up. First, there is no legal basis. Too often, systems are launched by policy directive or executive orders, not by legislation. Take the National Digital Identity System. It could transform how we verify identity nationwide, but there's no comprehensive enabling law. That's very risky when rights like privacy, equality, and access to services are on the line. Secondly, weak oversight. Our Personal Data Protection Act doesn't apply to government bodies. This means no independent authority checks how the state collects or uses our data. In practice, accountability disappears. And thirdly, exclusion. Digital systems often assume connectivity and literacy. In the interior of Sabah, those assumptions fall apart. A farmer in parts of interior of Sabah lost his welfare payments when the system moved online. The nearest registration point was 4 hours away, and even there, the connection failed. These aren't abstract problems. They're about whether the state even sees you as part of the system. So what should be done before governments roll out these tools? First, legislation must come before deployment, with clear rules on scope, oversight, and remedies. Secondly, there has to be an independent oversight, a statutory body with power to audit, investigate, and act. Thirdly, we need mandatory published impact assessments covering human rights and data protection. And fourth, inclusion must be a legal obligation, not just a policy aspiration, with language options, offline access, and systems built through consultations. This matters even more in plural legal systems. In Sabah, our native courts resolve customary disputes for indigenous people and are now being digitized. Done right, this can preserve culture and improve fairness. Done wrong, it risks distorting traditions, and deepening marginalization. Digitization doesn't erase the obligation to respect legal pluralism. It makes it more urgent. And we can't stop what's in front of us. The next wave will be AI-driven decision-making in welfare eligibility, immigration control, even criminal sentencing. If we don't set the legal boundaries now, these systems will start writing their own rules before we notice. Digital tools are here to stay, but if we care about the rule of law, we cannot let them operate outside it. Every system the state builds must meet the same constitutional standards as any law or public act: legality, transparency, accountability, and inclusivity. Technology should not lead the law. Law must always lead technology, and we must insist on that. Thank you.
Ladies and gentlemen, distinguished bar leaders, distinguished colleagues, I'm truly delighted to be here in India. It's my first visit, and I must confess that I'm enjoying it a lot. It's also the first time in 11 years that a president or vice president of the Paris Bar has made the journey. A personal pleasure, of course, but above all, a meaningful gesture. And I'm especially pleased to be here together with Marion Couffignal, member of the Council of the Paris Bar, whose presence underlines the importance we attach to this moment, to international dialogue among lawyers, and to the shared responsibility we bear in defending the rule of law across borders and legal traditions. And I would like to sincerely thank the Bar Association of India for organizing such an important convention, and above all, for your warm welcome. New technologies are a promise. They mark an important change in human history. We see it every day. Digital governance tools are already transforming the way we work. In France, for example, the civil case management, what we call mise en état, is now fully digitalized. In some cases, parties may also appear by video conference. But hearings themselves are not yet fully dematerialized because the courtroom remains an essential place for justice, especially for criminal cases. These examples show both the efficiency of digital tools and the questions they raise for the rule of law. Citizens, lawyers, judges, all of us now face a new reality shaped by digital technology, for better and sometimes, unfortunately, for worse. At every step, the same question arises: where will it take us? Will our dignity, rights, and value grow stronger or weaker? Will there be more or less equality, more or less justice? The answers depend on our ability to work together across fields and borders. And for sure, legal professionals have a key role in this. Our responsibility is simple, though difficult to implement: to steer these technologies, to support their fair and global development, and to limit their abuses. The digital space cannot be a lawless zone. Yet we recognize its benefits and harms coexist. We as lawyers must help to find the balance in between. No doubt that GAFAM and many other companies have profoundly transformed our lives. They have given us unprecedented access to information, to communication, to sharing, to exchange. And social networks, by bringing communities together, can encourage a more horizontal exercise of power. They offer citizens a platform for expression and mobilization to defend the rule of law and democracy. But power without limits leads to risks. But as well, a massive data harvesting, the algorithmization of our lives, misinformation sometimes amplified by artificial intelligence. And as we know, access to technology remains unequal. We must also beware of the risk of surveillance, sometimes invasive, whether by public authorities or private actors. The rule of law must protect citizens not only offline, but also online. And beyond privacy, there is the growing threat of cybersecurity. Cybercrime, identity theft, online fraud, all undermine trust and fragilize the rule of law. Faced with these challenges, the key questions are: who should set the rules and at what level? Knowing each country shapes a different relationship to digital technology. What kind of digital governance do we want to build? National, regional, or global? A governance that follows national laws, but above all, respects the core principles of the rule of law, of democracy, and of free societies. And let us never forget, digital governance should as well mean access. Access to law, access to justice. If technology excludes the most vulnerable, then it betrays its promise. Digital tools must reduce inequalities, not create new ones. And at the heart of this digital transformation stands, obviously, artificial intelligence, a revolution within the revolution. AI already transforms the way we live, work, and communicate. It offers huge opportunities, but also carries significant risks. Opportunities because AI can accelerate access to knowledge, justice, and legal tools. Risks because it can amplify misinformation, bias, and misuse of personal data. That is why new frameworks are essential. I think, for instance, of the European AI Act adopted in 2024, fully applied in 2026, it aims to create a single market where only safe and transparent AI systems can be offered. It is a first step to protect users and a model that may inspire others. But AI, like digital technology itself, is global by nature. No national or regional framework will ever be enough. Reflection on AI cannot stop at borders. Again, it must be global. And the debate on AI cannot be only technical or economic. It must also be deeply ethical. The way we design, deploy, and regulate AI will say much about the kind of societies we want to build. This is also the conviction of the Paris Bar. We are deeply committed to exchanging good practices and to collaborating with bars around the world on both AI and ethics. And at the same time, we want lawyers to be actors of innovation, not spectators. That is why we have provided AI tools to our 34,000 Parisian lawyers, so that none of them ignores the technology, so that all can familiarize themselves with it, so that AI becomes an everyday tool while fully knowing its risks and limits. These actions show that lawyers are not only witnesses of change, we are shaping it. Lawyers are not only guardians of the law, we are also actors of change, ready to shape the digital future. The rule of law and its principles go far beyond what I have shared here today. They are the foundation of our common values. But these examples prove that we are moving forward and that we are moving forward together. I am glad that we are gathered here in New Delhi to take part in this major debate. I am convinced that the richness of our perspectives will nurture concrete avenues for digital governance respectful of our rule of law. Tomorrow must bring fairness, shared success, and respect for each person's rights. We cannot let digital actors take away our freedoms. We must keep control of our choices, our data, our environment in every way. In that context, it is not certainty that guides us, but commitment. Commitment to make law a shield, not against progress, but against its arms. Commitment to defend freedom without blind love for technology, but without fear of change. Deep down, our role as lawyers remains the same: to defend freedoms, to defend dignity, and to defend the idea that even online, the rule of law must stand. Thank you very much.
Thank you, Madam, for a very insightful presentation which focused on the need to use new technologies, but how to ring fence it with proper safeguards to ensure that rule of law is maintained and individual rights and freedoms are preserved. Thank you very much. Now call upon Ms. Gayatri Raman to tell us. She comes from another perspective of what AI they can offer to us.
Thank you very much. Honorable Justice Prasad, distinguished panelists, fellow panelists, and everyone at the audience. Before I start, I'd like to record my sincere appreciation to the President of the Bar Association of India for inviting me to this conference and for your hospitality. And special thanks to Law Asia President as well and the rest of the Law Asia Exco for your continued friendship and hospitality. Thank you very much. Definitely, my perspective today is going to be a little bit different. To give you a little bit of context, LexisNexis is a legal and technology expert, which means we combine legal content, the laws, with technology, and provide that into a platform that provides accessibility and transparency. These are very big words. So today, I have a few examples to share, just to show all of us how this can work if done in the right way. Why do we do it? And why are we so passionate about this? That's because it's our corporate mission, it's our corporate purpose. We have our own rule of law equation: equality under the law, transparency of the law, independent judiciary, and accessible legal remedy. We talk about it all the time, and at the senior leadership level, we have this as our yearly, annual deliverables. We also lead the way in business for rule of law. We are very, very passionate about SDG 16, and we do a lot of work because we know this is where our strength is to support the rule of law. Okay, I think in the earlier panel, this was discussed as well. One of the honorable justices talked about it. 5 billion people globally, and so many of them live below the rule of law on a scale of 0 to 1, with countries like Denmark at highest and then Venezuela at the bottom. Our rule of law projects and our rule of law priorities focus on applying technology to law-related information. Okay? These are some of the examples. I list them down. We advise judiciaries on technology adoption, develop online systems, manage data as much as possible, and from a content perspective, laws. We work on managing laws, and we work on how to produce laws in a more consumable and digestible format to regular citizens, not just lawyers. First example, this is a simple one first, and everybody would know about it. We partnered with the International Bar Association. So we created together the Eyewitness of Atrocities is an app. It is downloadable in mobile devices, and it timestamps and GPS stamps all images and videos that are captured, specifically designed for war crimes. So once that is captured, it is transferred directly into the LexisNexis secured databases. And then it is processed for possible evidence to support prosecution of war crimes. To date, we have captured tens of thousands of images. Ukraine is an example. Myanmar is also another example. I think it's really important to understand that we can't just create an app and then expect people to use it. We need to also teach people to use it as well. And one of the impacts is that a military tribunal in the Democratic Republic of Congo found 2 commanders of Democratic Forces for Liberation of Rwanda guilty of murder and torture. And because they had access to photos and video evidence acquired by the app. That's how technology can advance the rule of law. That's one of our projects. The second project is a more simple one. This is the ADAM program. This is one of the projects of the LexisNexis Risk Solutions team. If you are aware, some of you might be aware, in the US, every time a child is missing or a child is suspected to be kidnapped, an Amber Alert is raised. And when that Amber Alert is raised, then you have a lot of authorities looking for the child across different jurisdictions, cross boundaries, state boundaries as well. ADAM uses fax technology. There are many, many small sheriffs in the US. The federal may not be talking immediately to the state law enforcement agencies. So it uses fax technology. It distributes missing child posters, information of missing children to the police, news media, everybody, as fast as possible so that people can find the child. And to date, this particular program has successfully recovered 155 missing children. Now, on to my personal favorite, because I was involved in it myself. I'm just going to describe a situation in Myanmar for you. This was 2013, 2014. If you landed in Myanmar, you would see people selling laws on the streets. They would be selling laws for $3 US, $4 US, and these would be paper, stapled haphazardly, and they would say this is the new law. You wouldn't know whether this was a legitimate law or not, you wouldn't know, but at that particular time, people were really, really invested in looking at the law, treating the law seriously. But they didn't know how to do it. They just, sold these for $2. On the other hand, from a digital perspective, for the longest time in Myanmar, if you used Facebook, you did not have to pay the fees required for data, connectivity, etc. So Facebook was free. Google wasn't. So the Myanmar citizens would use Facebook to do their research. that was the most bizarre thing that I experienced, because they would be going into Facebook to research everything under the sun. And can you imagine, I mean, Vanessa just talked about misinformation. Can you just imagine how dangerous that would have been, because you're looking through for information, maybe sometimes about the latest laws that were passed, and you're going to Facebook to do it, right? So that was a phenomenon at that time. That was what was happening at that time. I was invited by Daw Aung San Suu Kyi to support the advancement of rule of law in preparation for full democratization. At that particular time, things were looking really positive and encouraging and ambitious as well. But everything was in these formats. These were taken by me. You had the Burma Law Report, you had the books everywhere, and people were really, really excited about these books, but they didn't know what to do with it, and they didn't know how to communicate to the rest of the country. Everybody had a smartphone though. Everybody had an Android phone, everybody was using Facebook. So do you see the contradictory situation happening here? So where do we come in? Well, that's where our expertise is, right? So we started step by step. We had many, many projects that we worked on. What I would like to share is this particular one, which is because it's going to make the most impact. At that particular time, the Supreme Court did not have a proper online website or tool that hosts their case law, right? So we worked with them. We developed a judgment writing template, because you can have technology, but if you don't have the knowledge of how to use technology, then technology wins and you don't. So we had to create a judgment writing template. We trained 520 judges across one full year on how to use judgment writing templates, and we consulted on an online publishing process for the Supreme Court of Myanmar. And we also developed a framework for continued digitization of old court records. And why was that? Because they wanted to improve their ranking in the Ease of Doing Business Index. And I'll show you a few examples here. I don't know whether it's very visible, but you can see that at that point in time, this is how data was organized. I can't make sense of it. You have a civil appeal, you have no idea what these cases are. You cannot find anything. But of course, this was online, right? Technically you can, but it wasn't really helpful at this time. So what we did was we worked with them, and we created a way for the judges to upload their judgments in a specific format that people would be able to understand. The ratio decidendi would be clear, the holding would be clear, the parties' names would be clear, the judges' names would be clear. These are things that we do on a day-to-day basis. We just applied it to support the country at that time. And we did it in the Myanmar language. And until today, despite the fact that the coup happened, this site is still live. The judiciary is still uploading case law up there, and people can still access it, and lawyers can still access that as well. So it's really important for us to think about, yes, we have technology, but we also need the guardrails. Yes, data can be out there and can be made available to everyone, but data needs to be true data, factual, checkable, protected, and not necessarily open to misinformation and disinformation also. And of course, it's a work in progress. We do see that in many, many jurisdictions and many, many different countries, there are various levels of needs. And where we can, we believe passionately that technology is the way forward to make it accessible to more people. And we will protect the way we produce that as much as we can. These are some of our partners. We work together with multiple partners in Asia, this is us in particular in Asia, to bring rule of law to fruition in the specific jurisdictions. Thank you.
Thank you, Gayatri. I think that was a wonderful presentation, and I'm sure many of us in the audience, including me, is not aware of what you can achieve by using digital technology in the form of protection of human rights for vulnerable sections of society. I think it's a great initiative and I congratulate LexisNexis for taking that up. Last but not the least, request Amarjit Jing, Bedi ji to please come and enlighten us.
Honorable Justice Subramaniam Prasad, dignitaries on the dais, off the dais, friends, colleagues. I'm not going to read from all the pages. I am the last man standing, as the President said, before lunch, between now and dinner. So, and after my predecessors, the erudite speakers, what they have explained, I don't think I have much to contribute, except from Indian context, because a lot of friends have come from abroad. Explain some of the aspects of digital governance tools available in India, which has an impact in our daily lives, both in the courts and outside the courts. So I'll give you some examples. I don't want to read about it, but how it has made a difference in our lives and how law has affected us positively, negatively, because as just like in coins, there are two sides to it. So some of the digital governance tools available off the court are things like Aadhaar. I don't know if you have heard of Aadhaar, which is a 12-digit unique identification number for anybody in India who wants to access any of these services in the government or otherwise, banking, etc., has to have an Aadhaar. Now, I don't know if you know, India's population is probably 1.45 billion. But can you guess how many Aadhaars have been issued so far? It is 1.35 or 38 billion as of 2025. So virtually 95% of our population, I don't know if this data is accurate because there are probably few million children also, and children don't get Aadhaar when they're born. So the data may be skewed, that is some of the downside, but about 1.3 billion Aadhaar has been distributed, and you need iris scan, that is eye scan, and you need fingerprinting to get an Aadhaar. So everybody is uniquely identified. And the benefit of an Aadhaar is that if I want to open a bank account, I want to do a KYC, know your client. E-KYC, you want to open a stockbroking account. You want to transfer your assets, you want to sell, purchase. Everywhere Aadhaar is the common denominator. It links you. So the benefit of Aadhaar is that I don't have to, every citizen in India doesn't have a passport. Now, passport is a valid form of identification. But since everybody doesn't have and there are rigors to getting a passport, Aadhaar is much easier to get and it is treated as de facto identification. Now, we may use it for day-to-day activities, and the benefit of using it is that everything is online. Virtually, I can open a bank account without going to a bank physically, just using my Aadhaar by doing e-KYC. So my mobile phone is linked, my Aadhaar is linked, I can use it. Now what's the flip side to it? So much of convenience, so much of ease. The biggest flip side to it is that our entire data is now accessible in a server, both with my iris, eye scan, and somebody else can, if a data is hacked, it can be used, misused. There have been reports that last year some Chinese hacker was able to hack our Aadhaar data. Now what are the ramifications? We don't know, but all our data is lying in a cloud, in a third-party database, which if misused can have a complete effect in our life. We have been hearing, I don't know if you have read about digital arrest. There have been cases of people who have been digitally means virtually on phone calls, on WhatsApp, on FaceTime, on telephone, normal calls. They have been threatened that they have been arrested, and there is information which the police has, which is verifiable information, based on which an impression is given that a person who is sitting at home is arrested and he has to transfer X amount of money to get out of that arrest. Now, where are they getting all this information before they make, suppose I receive a phone call, I will not believe anybody if he says that you are under arrest because you have been you have been transferring X amount of drugs in through this Blue Dart service. But if he gives me credible information, this is your mobile number, this is your bank account number, from this bank account number X amount of money has been transferred, then I will fear that probably an authority is calling me up to inform me, and I may fall into that trap of accepting the conclusion, if I am not probably a lawyer, that yes, I have done something wrong, and if I do not pay up, I will not be released. I may have to spend some time in jail. And fear of going to jail is one of the, a coercive process which every ordinary citizen fears. So he or she may, under that apprehension, pay up some amount to get out of it. In that process, lot of people, lot of senior citizens, lot of innocent people have fallen into that trap and lost crores, means in hundreds and thousands of dollars equivalent, or their entire life savings to save themselves. So this data, which is now available everywhere, if misused, has a huge impact in our lives. We become digital, isolated, in all our life earnings get vanished into it. Similarly, another digital governance tool which we have become so accustomed to is UPI. I don't know if you have heard of UPI, Unified Payment Interface. You go to a kirana stop, you go to a street vendor, you want to pay him the money. If it is in few rupees, you do not have a change, you can just use a QR code and you can transfer it. It doesn't matter which bank account your money is lying, which bank account his account does he have, he will get the money. Even if it is few rupees, even if it is 10 rupees, 20 rupees, you can do a transaction. Now that kind of convenience has revolutionized our whole country. Now, I don't know, billions of transactions are taking place every day. We are so lucky to have that system. But again, the advantages of having UPI is again that easily our amounts are then transferred out. Our bank accounts, as Justice Prasad was saying, your entire bank account can be wiped out because it's so easy to get the money in and transfer the money out. We have Digi Yatra. If anybody is traveling from within India, from one airport to another, you don't need to print out a boarding pass. You don't need to stand in a queue to get inside the airport. If you are enrolled in Digi Yatra and you have downloaded your boarding pass, just like Apple Wallet, you can go to the airport, outside the airport. There are face scanning machines there. You can show the QR code of your boarding pass and you can enter seamlessly. It saves so much time. Earlier we used to stand outside the airport to get to our chance, when physically they verify your document and then let you inside the airport. Probably 15-20 minutes, half an hour standing outside the airport, depending on how busy that day is. But with now Digi Yatra, it is so convenient that you can go, you can seamlessly enter the airport and you can exit, enter. It's very, very convenient. But what's the flip side? Your entire data of which day you are traveling from wherever you are based, to which airport you are going, which aircraft you are flying in, which seat you are sitting in, how many times a month you travel, all that data is now accessible in that portal, Digi Yatra. Now, if somebody uses that technology positively, he can probably curate for you, knowing your preference, that, oh, you like to travel in, let's say, Air India. Next time you want to travel again to, let's say you're going to Calcutta, it will populate, or it will give you that kind of recommendation that Air India flight is available for such and such date, knowing your habit, because you are frequently traveling, all the data is available in the app. But unfortunately, that same data can be then misused if not properly regulated or not properly kept in that store. Is somebody actually knows when are those days when you are not in town, and maybe when you come back there is nothing in your house because he knows you are not in town. So these are some of the digital governance tools which have positive and negative. Now, talking about courts, I must say our Delhi High Court is most advanced as far as implementation of e-courts, e-filing, electronic hearing, that is virtual hearing, e-inspection. Earlier we used to go and do inspection physically. We had to wait whole day. Sometimes the person would not be able to trace the file. We had to come back because we couldn't get the file. Now you just online, you apply for e-inspection, and you are sent the link of the entire court file, and you can download the file in your convenience of your office in the middle of the night. You have access to the file and you are prepared to argue next day. Your court file is matching exactly with the file what the honorable judge is reading. So there is no confusion, you are well prepared, it is access to justice, it is easier, court's time is not wasted. You know exactly which documents are on record, which are not on record, you are better prepared. Similarly, you have e-filing. We had an issue, we earlier used to have an issue of limitation. If you don't file by such and such time, the registry closes, you miss the bus, you are delayed, and sometimes your petition, your case is rejected because of limitation. But now thanks to e-filing, you can file it in the evening, etc., even beyond the court hours. At least your document is on record for that particular day. So those are some of the positive. Now, what's the negative of electronic courts? I can give you only example from virtual hearing. You must have heard of virtual hearing. Lockdown was the reason why everybody adapted virtual hearing so efficiently and quickly in the entire system in India. We all became used to it. We didn't need to go to the court physically when the whole country was under a lockdown. We could we could appear in the court. Thanks to it, we could still run our homes because we were not having any work during those few months when everything was under lockdown. But thanks to access to virtual hearing, we were getting opportunity to argue, to present our case and represent our clients who needed our help most at that point of time. Now, that also led to other advantages. For example, if you are doing 2 cases in a day and one court is physically 20 kilometers away, so sometimes you don't need to go to that court, you save your time by virtually appearing from a different location wherever you are. And you still get to defend your case, you still get to represent your client. And it also saves the court's time because court is not giving adjournment or it's not passing over the matter for you to reach from A destination to B destination. But what's the flip side to virtual hearing? Flip side is we started taking it for granted, we misused it. There have been cases, I am very sorry to say, but there have been cases where people have been appearing from washroom while they were answering nature's call. There have been cases they have been answering when they were having a drink in their hand. They were appearing virtually when they were sitting in the car. So the tools which were given to assist us have been misused, and therefore, as my predecessors have said, that there has to be guardrails, there has to be regulations. It has to be used judiciously. It has to be used in a way that it benefits the system and not is abused by people. So with these few words, I like to thank you. There is so much to make progress, but tools are helping us. Thank you.
Thank you, Manjit. We have just 3 or 4 minutes. I don't think there's much discussion possible. But I thought just a couple of things that occurred to me is because we are now talking about rule of law as a vis-a-vis the digital transformation that has taken place in our respective lives. There are just questions which often arise as to what is the enforcement mechanism we have for this. Because as Amarjit rightly pointed out, we have a huge amount of data which is available now. Mobile phone data is often the best methodology that police use to detect crime now. If they know a mobile number, they're able to track where that mobile is. And when was it last used? Where is it going? And they're able to pinpoint you to the nearest mobile tower that is there where it is, your phone is connected to it. Now, this has also become a problem. I remember one case where there was a problem between the husband and the wife. The husband tracked her phone with the help of the police and slowly, surreptitiously went behind her and found her sitting with somebody else and shot her. So these tools and this information to be used by the law enforcement agencies, how equipped are our police? How well do they know how to detect a crime? Now often when these wrong debits come in your credit card. Now recently it happened that a person was in India and his card was used once in Dubai for gambling and once somewhere else. So immediately he notified the company but then the credit card company takes its own sweet time to pay. In the meanwhile, it says you pay this money and you pay interest on it if you have not paid, and it goes on like this. So how quickly will this be resolved? And what is the wherewithal of the police and the law enforcement agencies to track this is another issue which seriously arises for consideration. I'm sure we are having teething problems, and hopefully things should improve, because the cyber police today, they are smart guys. They are using now highly qualified technicians and technologists to assist the court. I know a young fellow who's from Bangalore, who travels half the time to US. He is on the call with the Bangalore police. If they find a difficult situation, they bounce it off him, and wherever he is in the world, he is helping them. Of course, he is doing it pro bono now, but they will build their own capacities. So I think that's how it's going to go. So it's an interesting field. It's been very useful. There's no doubt it has made our lives easier, but the flip side is this. So often when people complain of privacy, I ask them, do you have a mobile phone? I said, yes. Then where's your privacy? There's nothing like privacy with a mobile phone in your hand. Everything is known to everybody. The minute you see one advertisement for Saridon headache pill, how many advertisements you're going to get on your phone for that headache pill? It will suggest everything for headache, body ache, every other ache also. It will keep on telling you this. So these are intrusive things that are taking away our time. And the flip side is, it's good, but then it comes with all these things. How are we going to control it is a question which is a challenge for all of us. Thank you, and I request Justice Prasad if he wants to add anything.
See, the upshot of everything is that we can divide into four. All this is for people. The technology that, or the process that is to be used is to be simple. At the same time, there has to be robust safeguards. Safeguards both in the executive field and in the legislative field. So unless and until there is not an amalgam of legislation, a robust enforcement system, it will definitely be a boon. Otherwise, for us lawyers to search a case when we used to be juniors, to search from first the book, then from the digest, and then from the yearly digest, has now gone to a click of few buttons. It's a different matter that 4 out of 10, the context is different. But still it's made life much more simpler. But yes, a robust legislation and a good enforcement would actually make it much better. Thank you.
We'll close this session with grateful thanks to all the panelists and to Justice Subramaniam Prasad for sparing his valuable time and giving his very insightful comments. Thank you and have a nice evening.